Hi, welcome to My Court Coach. I'm Jaylyn, and I'm going to be your instructor as we navigate through Form DV-710. This is the notice of hearing to renew the restraining order. So in order for the other party to know about your restraining order hearing, the renewal of it, they need to receive this form. So you must have it filled out when you go ahead and file your request to renew the restraining order. It goes in line with notice and opportunity to be heard. So they're going to receive the notice and they're going to have the opportunity to be heard because the restraining order hearing date is going to be listed on here, and they could object or agree to your request for a renewal of your restraining order. So the name of the protected person is going to go on top here. Your lawyer's information is going to go there. The address, city, state, zip. If it's confidential, then do not write that information in there, but you must have some sort of mailing address, telephone, fax number, email address does not need to be listed on there. Please make sure that the name of the restrained person and the description of the restrained person mirrors what's written on your restraining order after hearing. Then the court's going to fill out the rest of this form. So they're going to fill out the date, the location, and the department or room of which your restraining order hearing for the renewal will take place. And then it's going to notify the other party that at the hearing, the judge can renew the current restraining order for another 5 years or permanently. Before the hearing, you can file a response on Form DV-720. You must continue to obtain the current restraining orders until the expiration date on the current orders or the hearing date, whichever is later. This is very important, and I'll tell you why. Because on your restraining order after hearing form, it's going to have an expiration date and time, right? And so let's say your request to renew the restraining order is actually after that expiration date. So to err on the side of caution, and sometimes strategic on some people's part because they want the restraining order to extend, is this request for renewal in fact extends the restraining order until the hearing date. So the restraining order after hearing, or the order of protection, stays in effect until the expiration date on that order or the end of the hearing below, whichever is later. So if this date is later than what's on your restraining order after hearing, then the court orders will remain in effect. The order of protection is going to remain in effect until this hearing date. So that may or may not necessarily be fair, depending on which side of the coin you're on. So at the hearing, you can tell the judge why you agree or disagree with the request to renew the orders. If the restraining orders are renewed, you must obey the orders, even if you do not attend the hearing. So if you fail to attend the hearing and the court feels that a permanent or a 5-year restraining order is necessary, it's going to go ahead and grant it, and you can't do anything about it after that. So service and response. So if you're the protected party, it's going to say someone 18 or older, not you or anyone else protected on the restraining order, must personally serve or hand deliver a copy of the following forms on the restrained party at least X amount of days before the hearing. So the court's going to give you the number of days. The request to renew the restraining order, so it has to be file stamped. The notice of hearing to renew the restraining order, which is form, which also should be file stamped. The response to request to renew the restraining order, which must be blank because it gives the party the opportunity to properly respond. And then the current restraining order after hearing that you want to renew, which should also be filed stamped. So after the restrained party has been served, you're going to file a proof of service form. And if you need help, you could watch one of our videos, and you should bring a copy of the form DV-200, the proof of personal service, to the court hearing in case the court does not have it in its file and the other party is not there. And so the court doesn't reschedule your hearing to come back to serve the other party when you already have them served. So it's best to bring in the proof of personal service to the court hearing. Now to the restrained party. If you want to respond in writing to the request to renew the restraining order, then you're going to fill out the 720. You're going to file the original with the court, and you're going to have somebody over the age of 18 that's not you mail it to the protected party before the hearing. And then you must also file a proof of service by mail with the court before the hearing, and you should also bring a proof of service by mail to the court hearing in case the protected party states that they did not receive your response. So it's a great way to object to that argument and respond to that argument. The judicial officer is going to sign off on this and date it, and the court clerk is going to date it and certify it by having the certification here, and then their name will also go there as well. We hope that you have found this helpful, and best of luck.